I call the Honourable Member Rahui Katane. Rahui Katane. Tēnā koe.
Tēnā koe, Mr Speaker, and thank you for getting my name right. The Māori Party is happy to support this bill. The consultation that we've been able to do with those who have expertise and experience in the field of intellectual and cultural property suggests that there is low risk to this bill and it is in fact worthy of our support. The bill establishes a mechanism to reduce the likelihood of New Zealand being used as a go-between to avoid other states' privacy laws. There are also provisions to ensure that personal data originating overseas and sent to New Zealand is subject to our privacy protection. We believe that the commitment to the protection of personal data, not only domestically but internationally, would highlight to other governments that we take the protection of privacy seriously. It has also been very positive that suggestions that came up through the Select Committee process have been taken into account. It reminds us and reinforces the view that good law is law which is shaped and responsive to the views of the public. In this bill, for example, the Public Law Committee of the New Zealand Law Society recommended adding a reference in the bill to international agreements, guidelines or principles that are relevant to trans-border data flows. This would include incorporating the OECD guidelines directly into the bill. The recommendation was agreed to by the committee and the necessary amendments proposed. This is exactly how the legislative process should work, and it reminds us of the importance of our Parliament and a government which insists that other countries be democratic, that our Parliament be seen to be a democracy also. The key issue for our discussion in reference to this bill is around the importance of international relationships. The aim of the bill to accede to the Madrid Protocol relating to the Madrid Agreement means that basically we are establishing a context for considering a global trademark. The opportunity to also accede to the Nice Agreement concerning the international classification of goods and services, as well as to ratify the Singapore Treaty on the Law of Trademarks, is one that we fully support. We do so because we see a global language, a relationship with other nations, as an essential opportunity to build respect and understanding across the globe. And I have to say, it is particularly timely on International Literacy Day that we are acting in a way that is consistent with our global counterparts. It is extremely positive that this Parliament will be giving effect to commitments that are consistent with international practice. It is from such a basis that we hope to establish trade relationships with other First Nations peoples. The bill may provide benefits to Māori business owners wanting to apply for trademarks, particularly if they are wanting to trade internationally. We also see support for this bill as totally consistent with acceptance of the United Nations Declaration on the Rights of Indigenous Peoples, which we see as one of the hallmark successes of the Māori Party relationship with the government in this turn of Parliament. Again, the timing is interesting. It was almost 4 years to the day on 13 September 2007 that the Labour government created such outrage amongst tangata whenua in their opposition to the Declaration on the Rights of Indigenous Peoples. That one act, along with the infamous raids undertaken under the auspices of Operation 8, the raids on Ruatoki, were certainly part of the context leading to Māori deserting the rank and file membership of the Labour Party. It is a history that was brought home to us vividly yesterday, with the not surprising revelations that charges would be dropped due to evidence being inadmissible. We must not allow these events to be forgotten.
Point of order, the Honourable Member Ian Lees-Galloway.
Mr Speaker, this is the third reading of the bill, and generally